disqualifying to the extent of freezing and paralyzing the 10th schedule at the instance of a person who has no locus. Your lordships would not even have a notice in the eye of law from a disqualified member. Therefore, the notice of this one person notice, this general notice, can never be a trigger for disabling the speaker. Can your lordships contemplate the notice of no confidence in the speaker by a person who has already lost his seat? Speaker S is only an ex post facto confirmer of a disqualifying event which has already happened. So, when I cross the floor from here to here, I have incurred, fastened upon me, the stigma of disqualification in law. The adjudicatory process happens and leads to a judgment which is necessarily subsequent. But, and that's why Lordship Constitution says, it relates back. Case after case. Now, Malas, kindly see how uneasily Nabam Rebia will sit with this principle, which is not even considered remotely by Nabam Rebia. So, Malas, the speaker is actually an ex post facto quasi-judicial confirmation of the disqualifying proceeding, which is 1 to 3 months earlier. Every case where I disqualify somebody, he stands disqualified not from the date of my order, from the date when he incurred. Because the incurrence is A, I cross the floor, B, I do statements, my conduct, the lordship says I can also do that. E, other things, the whole, I go to the governor, I do this. All that will be from that. Number 2, under the same conduct, I'm under point 1. The object of this document, I just write 2 constitutional bench, the 2 judgments. What is the object of this? Object cannot get the fruits of your defection by saying that I am defective. I am scheduled today. You, for a variety of reasons, conscious or unconscious near intervening, will enjoy the fruits of my not being declared a defector. That's the purpose of things. Now, Malas, if that be so, a notice given in most cases after the relating back date. I am now on the notice of Nabam Rebia, original 14-day notice. So, a notice given by a person, hey, I went to Surat, then I went to Goa. The notice admitted is given subsequent. If the speaker is allowed to decide and be disqualified, they should be disqualified 3 days before giving notice. Your lordships would not even have a notice in the eye of law from a disqualified member. Therefore, the notice of this one person notice, this general notice, can never be a trigger for disabling the speaker. Well, the first point is a matter of great moment. Your lordship harmonizes the entirety of 10th schedule. What Nabam Rebia would do is, 1, it would render 10th schedule a nullity. 2, render law-like relating back a nullity. And all without considering the issue also. Those 2 paras. They are striking.
Notice to the speaker to 622.
Is purportedly was 21, but it is into the speaker at 22nd. The files show that. The files were later on produced. At 11:33 a.m. Put by hand. There is a separate noting on the file very clearly, which was discussed in court, that follows A, no MLA has given it. It's through a lawyer. Therefore, the speaker said, I have to check the veracity. All that is renders the notice. That's why it was not officially taken on record and acted. So, when anybody gets in, you have to check whether an MLA actually.
You were to tell Twitter of your order.
Now, the
basis of case which says they got the principle of
relating
it back.
Now,
according to you, the defection takes place in the violation is 2nd of June.
21st.
21st.
That's
Okay, all right,
important.
21st. Whenever
Nabam Rebia says that a mere notice, for the moment we are only discussing, mere notice disables the speaker. Your lordship does not have to, he can't touch the six. Speaker were to decide at any point of time,
relate back.
it would relate back to a time when there is no notice of disabling the speaker. There'd be no notice of disabling the speaker. It's a different matter, but the courts take time, speakers take time. Back doctrine. In fact, relating back doctrine is otherwise vital. Speaker wants to be part on this matter to decide on his own sweet will or after a middle. So it has to relate back to the act. The man will leave his seat from that act. In the day if he leaves his seat, there is no notice by him. So can your lordships contemplate a notice of no confidence in the speaker by a person who has already lost his seat? There cannot be in law, Malas, a valid notice by a person who has incurred a disqualification which doesn't allow him to be MLA, but yet a purported MLA is giving a notice to a speaker. And that is the foundation of Nabam Rebia.
Then that determination is simple.
Correct.
Speaker, not
Malas will have back. No, but Malas, if it relates back, then it cannot be a simple kick off the rightness of this kind of doctrine. Either Nabam Rebia would have considered it. This aspect is not even considered by Nabam Rebia. And Malas, secondly, would have relevance. There would be a very strong reason.
Speaker, the notice of no conflict
Is by a non-entity
by a person who
has no status.
already
in the
incurred a
assembly.
disqualification.
That's the only. Otherwise, the lordship will not keep up the authority of the principle of relating back. And relating back is too far gone, Malas, into our jurisprudence for that to be questioned. As a matter of fact, lordship did have relating back. Selectivity by speakers also. Time. You can choose to decide this case in 2 days, 1 year, this case in 10 years. Then, Malas, the judgment which follows this and many more, just one more, Malas, is Srimant Patil, which is in your lordship's PDF at 1286 is the relevant. It starts at 1249. But your lordships will just note 1249.
Volume 1.
To 1286. Volume 1, same volume.
PDF.
The PDF relevant page 1286 para 92. So you are sanctifying to the extent of freezing and paralyzing the 10th schedule at the instance of a person who has no locus. On a point not even considered, you go to the 10th schedule. Just before this articles we read in the morning, 179, 180 and 181, just before 10 articles before Malas. Same chapter. Your lordship have a non-obstant in either? Does your lordship have a subject to it? Does your lordship have an override or a subordination in any of these provisions which you discussed in the morning and now? Answer is no. Never read it like the way Nabam Rebia has written. It cannot be read then. On elementary principles of statutory construction, leave aside. Another elementary principle, or should not read a statute like this. Here, you are disharmonizing the same chapter, the same constitution. You are imagining and creating a collision. This links to the argument, Malas, that the two were intended to operate in separate planes. That's why a lordship doesn't have an override in one and an underride in the other or a subordination in the other. They were supposed to operate in different planes and simultaneously. But the effect is that without applying principles, Malas, which are known to interpret anything, you have achieved that result. That's point number 2, Malas. This point number 3 relates to the third, as Mr. Sybil said, Malas, I will deal with in one part of the submission, but I won't read the submissions first. I want to point out what the words are. Let me give the point, very, very interesting. How completely, with respect, these words have been misread. Nabam Rebia. Each of these points I am making are enough to refer it to. It's complete misreading, and now we have evidence from the debates that it's a misreading. We have evidence from debates. Let me explain how. And there is Keher judgment. Okay. Justice Keher judgment, who says that we don't appear to have discussed in the debates. So I'll show those debates. This itself is conclusive. Now, but forget the details, but just first see the concept. Well, it's the question of Mr. Tahir Mohammed and others raised it. And the separate part of the discussion where Mr. Ambedkar says that this means, one, that the total strength is taken in for the majority, as my Lord observed in the morning. But it means that this will not count the vacant ones. Namely, vacant posts or seats are not part of the then assembly. Raise your Lordship is considering is the then assembly. The then assembly will not have in the counting a vacancy by way of disqualification. The whole thing fits in perfectly if your Lordship sees that. I remember when Mr. Dr. Ambedkar was speaking, there was no 10th schedule. But there were lots of other disqualifications. Identical to the 10th schedule in the same article as the 10th schedule. 10th schedule is added to the same article later on. So whereas he was talking of those disqualifications, saying that the then assembly cannot count vacant seats. On the same parity of reasoning, a disqualified member, the seat becomes vacant. On the same article. I hope I'm clear, but I'll show the articles. On the same article to which 10th schedule is later on added, if I disqualify him, that seat is vacant. That cannot count in the then assembly. So the intention of the framers was not to count it. The intention of the framers was what fell from the Honorable Chief Justice in the morning to create a majority threshold. It was actually marrying two unconnectables in Nabam Rebia. My lords, the question: what is the harm which can be caused by not disabling the speaker? If I paraphrase and rephrase your lordship's question. Now, there are 5 items. This has been argued. Item. Bear in mind one thing. If in any case the trigger can be only when that 7-day notice is there and then it is taken up for vote. The maximum is 7 days. Unless your lordship holds that the 14 days is valid, which is outside the voting. So, well, your lordship, keep in mind how much harm can be done in those 7 days. Only after that resolution, that we assume either way, the speaker acts earlier also on the first. I'll do it either. Lord has to do a balancing ultimately. I want the larger picture, please. Constitutional balancing and harmony is the most important. The Constitution doesn't provide for everything. It does it every day. Now, if there is an omission, simple answers are A, 7, and apart. That's only one. B, that lordships have called 10th schedule acts of defection constitutional sin. Not my word, is the Supreme Court case. It's the constitutional sin and a political sin. By the whole act. Then the balancing is third, C, is on the one hand a stoppage, a cessation, a paralysis of 10th schedule versus the speaker continuing to act in all ways except on the day of voting. The ultimate answer is D only. That if your lordships ultimately has a reinstatement, let's first as well as a disqualification, which is wrong. The disqualification is right. If it is wrong, then that ruling by either a court or anybody installs those members right back. And you can reverse the speaker's continuance immediately. But can your lordships reverse the opposite? The speaker is removed today by a simple notice of that one case outside the session. The government falls. Exactly the facts of this case. A new government comes, a new speaker comes. Well, does your lordship's judicial review allow that reversal? So it is irreversibility versus reversibility, which your lordship will put in the calculus of balancing.